Hello, hello, hello. I would love to see and talk about immigration and advanced parole and deferred action and see what's going on. So I'm not sure if I see any questions yet. Um, let's see. Um, let's see. I'm not sure if I see any questions. I'm sorry. I'm in the live link and I'm not sure what's going on. Hi, how are you? Um, let's see. Hello, hi, how are you? Hi, Dania, how are you? Hello, hello, hello. Ask me any questions. I'm an immigration attorney. I'm licensed in the state of California, do immigration across all 50 states, and um, represent family based petitions. And hi, how are you? And I just want to answer the next hour a whole bunch of questions you might have about immigration. So post them in the chat and let's go. Citizenship turnaround. How long is it taking to become a U.S. citizen? Average time across the U.S. is about 16 months. Yeah. Does DACA make it easier to get adjustment of status with marriage to a citizen? Yes, it can. It can, because if you didn't have a last legal entry, let's say you entered when you were 2 years old without inspection, right? Your parent brought you from Mexico, let's just say. Thank you so much. And let's say you are now married to a U.S. citizen. You could get your green card here in the United States if you file for, hi, Vanessa. Hola. You file for advanced parole. And advanced parole is where you go out and come back in with permission. Then you have a legal entry, and that's called then your husband or your wife can apply for your residency based on immigration law 245A. Yes, so it does definitely help. If you haven't done advanced parole and you don't have a legal entry, then it might be something you should consider doing. Okay, this person asks, I have a younger brother who's 38 years old now. When he was about 16 or 17, he was charged with a felony because they found 1 ounce of cocaine in his truck. Years later, he got it reduced to a misdemeanor. He got married, and glory be to God, he now has a successful company, roofing. He has children and his wife who has DACA. So one of the things that the question that comes up is, was that even a conviction? Because for immigration purposes, if this proceedings happened when the person, your brother, was under 18, then technically, unless he was in charge as an adult, and that's very few and far between, those juvenile incidents are not in the criminal courts. They're in like a juvenile court, and they are not convictions for immigration purposes. Hopefully that helps. But what I always do is people hire me to review their criminal record and give them an opinion letter about what the immigration consequences will be. And they do that if they're going to plead to something. Before they plead to it, they hire me to review the plea documents and stuff. And I do a substantial amount of that work, and it really does help our clients. Can you travel internationally with advanced parole? Yes, you could travel internationally. Hello, why would USCIS tell me to send a letter when I'm asking for updates on my U visa case? So, when you're inquiring, this is a really good question. When you're inquiring about a U visa, you actually can email either the Vermont Service Center or the Nebraska Service Center, and they will you put your name and your A number, and you send them an email. Within like 5 to 6 business days, they will respond to the email. That's how that unit does it. So hopefully that answers your question. what is happening with DACA? So DACA is now with the district court judge. It went up to the Fifth Circuit, and the Fifth Circuit remanded it, basically sent it back to the district court. And what is promising is that the legal argument about deferred action when President Obama did it was that it didn't comply with the Administrative Procedures Act, where it's a law that allows people to comment on potential new regulations and laws. And so one of the arguments that they've been prevailing on, people that are not for the DACA, is that it didn't comply with the Administrative Procedures Act. Now, the great thing is during this time of the appeal, President Biden did comply with the Administrative Procedures Act and published the final regulation at the end of October 2022. And the Fifth Circuit directed the district court judge to determine not only whether President Obama's executive order was constitutional, but if President Biden's regulation is constitutional. So I think there's a good chance that that judge may say, I still agree with my prior ruling that with the way that President Obama implemented the DACA program was unconstitutional. But notwithstanding that, this new regulation did comply with the Administrative Procedures Act. And if he does decide that, then it could be that the new DACA applications get to be submitted. So we'll see. I let my DACA expire after I gave birth to my first child, and my fiance and I went to get married. Should I try to renew my DACA again before we try to marry? If it has been less than 1 year, definitely renew your DACA, because remember, it's critical to keep deferred action status. And I tell my clients all the time, even if you're going to file for your green card, keep your DACA current, because you want to make sure that you have that sort of protection through the whole process until you're a green card holder. Yes, it will be another $495, but what happens if your green card application gets denied or wrongly, or maybe you're not entitled to your green card? You don't want to, hi Elizabeth, you do not want to lose the chance to have DACA. Thank you for sharing this live. Thank you. I'm on TikTok live too. Can someone apply for advanced parole information? For an information path after having their parole in place, work permit approved, not through adjustment status yet? Okay, so someone's asking if you have parole in place and you have a work permit, can you ask for an information pass? Yeah, anyone can ask for an information pass, which is essentially wanting to go speak to an immigration officer at a local office. You call the USCIS and you tell them the reasons why you wish to see an officer. Urgent matters are, for example, we're talking about advanced parole. Let's say you file for advanced parole based on DACA, you get the receipt, and then you based it on someone being sick and you want to visit your loved one, let's say in El Salvador. Then they get very sick, and you could call the USCIS, ask them for an information pass because it's urgent. You can take your passport, your Salvadorian passport, your DACA approval, your receipt notice for advanced parole, and all the documents to establish the health of your loved one and the urgency for which you need it. And sometimes they can stamp that advanced parole directly that same day in your passport. Now, I have seen, it's really strange, but I have seen some people that go with the receipt having already paid the filing fee for the advanced parole. Some of them, the officers will make them pay again. So if you're going to do this, it's really important to bring a backup filing fee in case the officers ask for it. You'll be able to fee it in right then. You are welcome, Alejandra. Good luck. Yeah, someone's saying, yes, you have to pay again. So I've had like 3 clients that have done the InfoPass, and they didn't have to pay the filing fee. And then I've had a couple others that had to pay the filing fee again. I applied for advanced parole and got approved. I'm in Oaxaca right now, heading back to the U.S. Sunday morning, married to a U.S. citizen. We'll start to do adjustment as soon as I can. How do I start? Awesome. Well, I hope you're having a really good time there in Mexico. And if you can start right away. So the first thing to do is consult and go through all the intakes and make sure that you're eligible to adjust status. And then if it looks good, then we can file for your green card. And the cool thing is, when we file for the green card, you can also file for advanced parole based on the green card application or the adjustment of status application. And if it's issued during the pendency of your green card, you can go out and back to the U.S., out of the U.S. and back multiple times on that advanced parole. Even though you're keeping your DACA current, like I told you got to keep your DACA current. It's the safest thing. You don't have to do advanced parole based on DACA again, because you can apply for that when you file for your adjustment of status. Yes. I work in all 50 states. Everyone's saying, okay, how long is the process taking to fix a father of a citizen's son? That really depends on the immigration history of the father and the criminal history of any of the father, and how the father entered the United States and how many times your father might have entered the United States. So it depends. If you're, and also if he came in without inspection and he doesn't have a qualifying relative for the 601A waiver, which is the pardon that he'll need for the 10-year bar, which likely he has, then he can't file for his green card, okay? Because he won't have a qualifying relative. This was answering a question. Do you have to have the COVID vaccine in order to adjust status? So the government requires the COVID vaccine for adjustment of status. Oh, can you put that question up again? Oh, the immigration judge ordered removal back in 2019. I was granted DACA even after being detained. I was approved advanced parole for 30 days since yesterday. Is there any risk even with approval? No, there is not a risk, because the case of our belly, your belly makes clear that even though you're physically departing the United States, you're not legally departing the United States. So you don't effectuate the removal order. In other words, you come back, the removal order is still there, but you haven't deported yourself. I'm trying to say it in simple terms, so it's very safe. And that is supported by case law and my own private experience doing hundreds of deportation cases. What could prevent someone from adjusting status after AP with U.S. citizen's son or spouse? Well, the first one that comes to my mind is the permanent bar. So the permanent bar, oftentimes people don't know that they have the permanent bar because they might not have known that when they were 3 years old, they got deported. So I always do a FOIA request, a Freedom of Information request for all my clients to get their entire immigration record. So that would be a removal order that they weren't aware of, which would be the permanent bar. The permanent bar could be a problem. Criminal matters. Oh, thank you so much. So there's many factors, and I can't tell you. I mean, I've done hundreds of deportation cases and hundreds of adjustment applications, and there's a lot of different factors that go into it. But those are the few that jump out at me right now. Let's see, answering a question. How long does it take to replace a certificate of citizenship? Look at the uscis.gov website, and they have a processing time. I would, but I can't get off this live. But I think it's like 9 months or something like that. Can I explain the 601 waiver? So a 601, there's a difference between the 601A waiver is the provisional waiver to be forgiven for the 10-year or the 3-year bar. And then there's a 601 waiver that you can file to be forgiven for many things like a crime, visa fraud, misrepresentation, other grounds of inadmissibility. But if so, for example, let's say someone's here in the US and they depart in consular process and they already have the 601A waiver approved because they had to cure the 10-year bar or be forgiven for the 10-year bar. But they have they have 2 criminal convictions, and one of them falls under an exception and the other one they do a waiver for. They would go to the consulate. If the consulate officer says they need to file a waiver, then they would file the 601 waiver. The 601 waiver form has about 20 different things that you can check to be forgiven for. Okay, so I think everyone's talking about the 601A waiver. So I'm going to put it very simply. It's taking 33 months for the 601A waiver to be adjudicated. Now, before the pandemic, those waivers, we were seeing them take about 11 or 12 months to get approved, okay? And after the pandemic, the processing times got completely backlogged during the pandemic. Now, there is a federal lawsuit pending, like basically telling the immigration office, this is ridiculous in non-legal terms. The fees that were paid for the waivers are supposed to pay for the employees for the Department of Homeland Security. So how is it that you guys are behind on the application processing when you should be staffing this staff to adjudicate the 601A waivers? Does that make sense? So there's a lot of litigation right now. Yes, it does take 32 months to get a 601A waiver approved, but I would file it if you can. Thank you so much for following me. I truly appreciate it. So nice. Thank you for all the likes. So let's just think positively and believe that the waiver will get adjudicated sooner. But as I want to get back to the 601A waiver, if you come in the United States after 1997, April of 1997, this is when the new law was implemented. If you have been in the United States without status for 1 year or more, and you depart the United States, you have the 10-year bar, which in other words means you cannot get your residency for 10 years. Now, before the 601A waiver was implemented, which was like, I think 6 or 7 years ago, people never wanted to go get their green cards because they would go trigger their 10-year bar, go to the consulate, then they would have to file the 601 waiver to forgive the 10 years. And they're like, I'm not doing that. I can't leave my wife, my kids, my job, everything. So the 601A waiver literally pardons you before you need it. Okay, because you don't need it until you put your little feet outside the US. But what they're doing is they're saying, we're provisionally granting you the waiver, and then when you leave, you'll have it. And that way you won't have to wait outside the United States to cure that 10 years or to wait for the pardon to be approved. Okay, once I have a legal entry, can I do adjustment of status with a U.S. citizen parent? Okay, if you don't have any other grounds of inadmissibility and you're under 21 and unmarried, yes. If you're over 21 and or married, most people cannot adjust status in the United States like others because you are now not an immediate relative. So immediate relatives are children that are under 21 and unmarried of a U.S. citizen parent. In that case, though, if you couldn't adjust status, your parent could file for your green card and you could consular process. And you could claim 601A waiver could be based on the hardship to your U.S. citizen parent. So hopefully that helps. Does a person have to complete 10 years in the country to get a permanent bar taken away? Yes. So a permanent bar, if you look at the words permanent, it's permanent. In other words, if you have the permanent bar, you have to cure it outside the United States doing the 10 years. You cannot do that time inside the United States. After USCIS sends the adjustment of status to the local office, what's next? Fingerprints, then usually an interview. But if your application was complete, it might not be sent to the local office, and it might be adjudicated directly at the service center, which I'm seeing quite a bit happen. So it's exciting. They don't really tell you when it's going to go to the office. You're very, very welcome. You're very welcome. Like, I don't know when my clients' files are getting sent to the local office. When they get transferred from service centers, I do, but not if I don't know when they get to the local offices. Can you apply for adjustment status right after getting back from advanced parole? Cynthia, it depends. So I'd have to look at your entire immigration record to really tell you. But let's just say hypothetically, you don't have a criminal record. You came here one time without inspection. You're married to a U.S. citizen. You have DACA. You go out, come back in on advanced parole. You've been paroled in. In that situation, you can file for your residency under 245A, right? Because you're an immediate relative. You're married to a U.S. citizen. You don't have the permanent bar. And if you don't have a criminal record, you don't have any other grounds of inadmissibility, you should be good to file. But again, I always review every single one of my clients, my potential clients. We have an intake. I personally do them, and I review their entire immigration record, criminal record, and do a FOIA, which is a Freedom of Information request, just to be on the safe side, because it is quite expensive to file for a green card. And the government filing fees alone are expensive. And then if you have to hire a lawyer on top of that, well, you don't want to waste that money if you are not eligible to file for your residency. If a TPS recipient travels with a 512T and returns to the U.S., do they now have access to the 245K exemption for employment-based adjustment of status, especially after the July 2022 USCIS rescission of matter ZRZC? Okay, so that's a little bit of a complicated question. I will say, generally, there was a case that people that had TPS went out, came back in on advanced parole. They were limiting those people from adjusting status in the United States. That case has since been rescinded by this current Department of Homeland Security, and many people can adjust status in the United States now. And I would have to look at your, like, that whole record to know whether you could file for adjustment of status. But I kind of feel like in the back of my head, you could. Oh, cool. I got this great question. They waived my interview and asked me to send the I-693 medical, but till now they didn't send me the green card. So the I-693 is a medical exam, I believe. The medical exam needs to be, thank you so much, Clara, needs to be sent. This is good news. If they waive the interview and all they need is an updated medical, awesome. Then get it to them. I'm so happy for you. That's so good. Can a person who has military son-in-law adjust status? Great question. Some people can. So if your child is in the military and a U.S. citizen, and you can apply, the parent can apply for what's called parole in place. That's where you get literally paroled in place. You don't have to go and come back into the U.S. Many people with that, just like advanced parole, doing that with DACA, they were last paroled into the United States. So barring any other grounds of inadmissibility, when that child turns 21, they can file for their parents' green card. So, but I want to let everyone know that, let's say the child is 18 and in the military, you can file for advanced parole when the child's 18. You can renew it. The parent can renew the advanced parole work permit. And then when the child turns 21, can file for the green card, assuming there's no other grounds of inadmissibility, it's a great opportunity. I've done a lot of these cases and people are so relieved. You know, it's a great honor. You're so welcome. Thank you so much, La Lucy. Oh my gosh, thank you very much for all the likes. Um, thank you so much. Let's see. I got a letter, didn't send my medical exam. Should I send them or wait till they ask for them? That's a good question. I would probably wait for them to ask you for the medical because you want to respond to that so that the officers know where to put the medical. And oftentimes things get lost if it's not in response to like a request for evidence. So I would wait. Yes, USCIS is waiving a lot of marriage-based interviews at the moment. Yes, because so they get the adjustment of status or marriage-based green cards are getting sent to the service centers back east and some in California and different Texas and stuff like that. And the officers have been directed to review the application, and if it looks like everything's in order, then they can just grant the green card and not send the file to the local office to have an interview to ask the couple the same questions that they've asked in the application itself. Yes, I do consultations across all the United States. Mm-hmm. Brother-in-law was deported a few years ago, but came back. They went to a lawyer to see possibilities for a green card, but they said he can only get a green card by going to Mexico or if he suffered from violence. Well, Elizabeth, what your brother-in-law has would be the permanent bar because he came back to the United States after having been removed. But there are exceptions. Like if you file for a U visa, you can file a pardon for the permanent bar, and they can forgive you for that. Can a person get a green card if they have a felony? It very unlikely, and it depends, and there are standalone waivers for that. I mean, there's waivers for that too. What are good methods of proving metropolitan entry for adjustment of status purposes, or entry with an old border crossing card back in 1990s that did not generate an I-94 at CBP records? Excellent question. Okay. In that situation, when someone had old border crossing card, first of all, I obtain a copy of that if they don't have it, and I can do that in the FOIA because the FOIA is going to be in their immigration file. Then I submit a declaration. Along my client's declaration along with the border crossing card, and I submit a report that it's a congressional report that talks about people being waved into the southern border, and how it's a common thing. And if I have anyone, if this person came back in with anyone, I have them submit an affidavit, a sworn affidavit also. And look, immigration knows that if someone has a border crossing card, they're not going to walk through the desert and come in without inspection. They obviously come in with the border crossing card. And many times they're just waved into the U.S. Like, if you've ever been to the southern border, especially like big ports of entry, like Tijuana and Juarez, if you just show them something, they oftentimes just wave you through. They're not going to take the time to pull out your passport and stamp and put the I-94 in your passport. Now, things could change as they digitalize things, but for the most part, that's how I approve. That's how I approve. That's how I prove. I've spoken too many times today, too many consultations. A waived in case for adjustment of status. But make sure you get the border crossing card, a copy of that, okay? Sometimes I kept them. They might have their original. How can I get an I-94 if it's not online or was given one? So if you weren't given an I-94 and it's not online, it doesn't exist. It's going to be just, I mean, I would do your FOIA to see if there's any record of it. And it would just be your declaration, your sworn declaration about how you entered. This is a very good question. Can I travel to a neighbor country from the one I was paroled to? So you're not paroled to a country. You're basing advanced parole on humanitarian, educational, or employment reasons. Now, CBP, I'm just thinking, I'm not sure that's a great idea, because I think that's a little risky to go to another country, even though when you come back, they're going to ask you. The CBP officers are starting to hassle people, but there's no legal reason to deny you back in. They might say, "What'd you do? Where'd you go?" I think if the officer sees another stamp from a neighboring country, they might put you into secondary inspection and give you a little bit of grief. I'm wondering if that's gonna. Maybe that is gonna. So I'm not sure. It's a great question. I don't think, if anyone is a lawyer here that's on the live, I'd be really curious to know what you guys think. I think it's not a good idea. There's something, having been a lawyer for a long time, something about it doesn't seem right. I have DACA and want to apply for advanced parole, but I gave a misdemeanor on my record 19 years ago. Would I have an issue coming back? No. The criminal record doesn't. So when you come back in on parole, they're not determining whether you have the ability to get your residency in the United States. They're just complying with what the USCIS said, is that you can be paroled back into the US. Okay, so if you have a misdemeanor conviction, I don't think it's a big deal. Besides DACA and TPS, what other statutes or quasi-statutes are eligible to request advanced parole? Anyone that is filing for adjustment of status can ask and request advanced parole. You file that with the green card application, adjustment of status application. If you didn't file it with the green card adjustment of status application, then you can do it later. You can submit the receipts and the I-131. You'll have to pay the filing fee though. Employment cases, many employment cases, you can obtain, you can travel outside the United States and back in, and you can get advanced parole based on some employment cases. Oh, that's interesting. If I have a child who's in law enforcement, can you be eligible for permanent residency? So a child in law enforcement doesn't give, that I'm aware of, doesn't give you any different rights. If they were in the military, it would, but I don't think that you're saying law enforcement. So the answer is likely no. Okay, Marcel, can someone with DACA status, only parole in place, work permit, apply for advanced parole, doesn't qualify for adjustment status? No. So this is a situation where someone doesn't have DACA, that has parole in place and has a work permit. And they're not filing for their green card, maybe because they have the permanent bar. There is not a basis to seek advanced parole based on those facts that are presented to me. In 1994, immigration caught me 3 times. My last legal entry was 1995, and I have not left. My citizen daughter can petition for me. Well, that's a great question. So prior to April 1997, back and forth, in and out, didn't trigger any grounds of inadmissibility. And you did not get deported either. So to answer your question, I don't know whether a U.S. citizen daughter can apply for you, but these activities, these ins and outs of the US that happened in 94 and 95 are usually inconsequential to a green card application. My parents are going to do adjustment status soon. Do they have to do the waiver because I came here illegally? Because I came here illegally. I'm not sure. Is someone else applying for your parents or you? No, you're not applying for them. There, oh, I get it. There could be your parents could be subject to the alien smuggling charge of inadmissibility for which there is a waiver. And if it's clear that they did, like your mom or father did bring you into the United States illegally, and they reflect that in the application or during the interview, they will likely have to file a waiver. It's on the 601 form for alien smuggling, which is based on the totality of the circumstances. And they can file that simultaneously with their adjustment application, admitting that they did. And this is happening more frequently because oftentimes in the DACA application, the children will say, my mom brought me walking through the desert. And then it puts the mom in a position where there's record, if they put the files together, that the daughter is saying that the mom brought her, and how would the daughter know but for the mom telling him or a family member? So just be careful about the alien smuggling charge of inadmissibility. It comes up quite a bit. I have an interview this March in El Salvador. How long after the interview will I get my green card? First, that is awesome news. That's so great. They will take your passport, and if they want to approve the green card visa, they will stamp the visa in your passport, and then you pick it up at, in Mexico, it's a DHL office. I forget about El Salvador. It might be DHL also. It's very short period of time, usually a few days to a week. Yes, it's so exciting. And that visa is generally valid unless it says something different for 6 months. So you don't have to like hightail it back to the US. You could take a week or 2 or 3 or 4 a month, but make sure you read the visa. I don't want to have you overstay your, visa. Can the 601 waiver for alien smuggling be filed within the U.S. for adjustment of status? Yes. So if you know that you for sure smuggled a child into the U.S., which is broadly defined, and you think that USCIS is well aware of that, then you can, when a person files the adjustment, they can file a waiver to waive the alien smuggling along with the adjustment. What happens at the consulate is if they admit to facts or the immigration officer is aware that they alien smuggled, then they could be denied or referred their visa, and then it'll indicate the INA code or the act, the section of the Immigration Naturalization Act, and they'll check 601 waiver, which means that you have to stay in your country and wait for that waiver to be adjudicated. Okay. For the consulate, there's no way to ask for the pardon before if you're consular processing. Thank you so much for all the likes on TikTok. Thank you. I really appreciate it. I have a little goal of 20,000 likes, so hopefully you'll get it. We sent our waiver a bit more than 2 years ago. Is it normal to take this long? So you're speaking about the 601A waiver, and it is not normal that it takes this long, but in your case, it is, because it's 32 months processing time. I think I looked at it today. It was 34 months, if you can believe it. If I have DACA and expires in May 2023, just received C14 through U visa. Since the U visa is not fully approved, should I still renew DACA, and what work permit category should I apply for? So you just were put in deferred action based on the pending U. I had a client like that where they got deferred action based on the U. They filed for the work permit based on the U, which I would do. Okay. Because you want to be in deferred action status based on the U in the event that the courts or the litigation and take away DACA. But if you try and renew your DACA, sometimes they won't give you the work permit based on DACA. They'll put you in deferred action status, but they won't give you the work permit based on DACA because they've already given you a work permit for the pending U visa. So hopefully that helps. God, you guys are bringing the questions. Complicated. Okay, I've got DACA when I was 24, no criminal record, never been arrested, and no traffic tickets. I got my AP approved last month and would be traveling soon. Excellent. Would be any issues coming back because of the accrued unlawful presence before I got DACA? Absolutely not. It's not going to be a grounds for the CBP officer to deny your parole back into the U.S. None at all. And I hope you have the best time ever. If I am grandfathered under 245I as a derivative beneficiary and I'm planning to adjust status via employment, can my undocumented spouse also adjust with me under 245I, assuming they would have to pay a separate $1,000 penalty? So if you're not the direct beneficiary, then your spouse cannot be grandfathered or be an after acquired spouse. Because you're the derivative beneficiary, I believe, hopefully I'm not wrong, that under that situation, the spouse could not adjust under 245I. Again, if they're the primary beneficiary, then yeah. Okay. What happens if I miss my interview because I was having a child? How long till I get another interview? Well, congratulations on the child. You should write to where the file is located, and you should let them know, give them a copy of the birth certificate, medical records, saying that this is the reason, ask for it to be rescheduled. If you haven't gotten a notice now that it was denied or for abandonment, then get on it right away. You're so welcome. You're so welcome. Thank you. I have 10 more minutes left in this live. I'm trying to get to 20,000 likes on TikTok, please. I really appreciate it so much. I have DACA and now I have a legal entry. My daughter will be 21 in 2024. How soon can I adjust status? So your daughter's going to turn 21 in 2024. You have to file when your child is 21, not any time before. So there was somebody that came to me and they filed the application like a week before the child turned 21, and they rejected the application. So you don't want to have that and then have to refile. So the person has to be eligible at the time they file. That means the child, it could be the day of their birthday or the following, days that follow, but not before. If someone has a permanent bar, applies for VAWA, would they approve it? If so, can they take the VAWA away? So you can apply for, there's complicated things here. VAWA is that you can file an I-360 even though you have the permanent bar. Whether you can adjust status after you get the I-360 is a question of whether you do have the permanent bar, because the permanent bar for adjustment purposes is a grounds of inadmissibility, even for VAWA petitioners, some VAWA petitioners. Thank you so much. 5,000 more to go. Thank you. You are welcome, Nancy. You're so welcome. I love how this live pops up for me. I'm an immigration service officer. Well, Natalie, thank you for your service. I love it. I have no idea why it popped up, but I'm a good lawyer, and I like that you're here because you can keep me honest, and maybe I'm saying something that's not correct. You can say, no, I don't think so. Husband and I have DACA and did advance parole. My son just turned 21. What's next? Well, it depends. If your son turned 21, then there's a chance that you and your husband can get residency, but it all depends on your entire immigration status, your record, and your criminal record of each person. So I don't lump people together because everyone's different. Every single case is different. Every person is different. And even when there's derivatives to an application, let's say those people still need to be reviewed, and they still need to be admissible or be forgiven for their grounds of inadmissibility. You are so welcome, Elizabeth. I've got about 7 minutes more. Oh, I got my goal. Thank you very much for the 20,000 likes. I have a consulate appointment in Honduras. Awesome. I have DACA and received it 60 days after my 18th birthday. I'm afraid to attend the interview as I'll be forfeiting my DACA. I'm trying to do advanced parole instead. Should I be afraid to attend my consular interview? Okay, there's a lot to unpack here. Let's just say there is a special rule when it comes to deferred action. There's a policy that says that if you receive DACA when you're under 18 or under, you don't trigger unlawful presence. But that's also true if you have unlawful presence less than 179 days before you got DACA, because that means you will not trigger the 3 or the 10-year bar when you leave for the consulate. I've had clients that have this exact situation. They didn't need a waiver because they have not incurred unlawful presence in the United States, and they are able to depart the United States. What I do for my clients is I prepare a letter with all the supporting documents in case the officer questions them about why they didn't file a waiver. Then they can present it right to the officer. I don't tell them to give it to the officer right when they get to the window, but I have it for them. In the event the officer says, wait, you didn't file a waiver, then they can no, here's a letter from my lawyer. And it explains why my client doesn't need a waiver, why my client didn't trigger the 3 and the 10-year bar. So it sounds like you're going to be okay if you have a good lawyer and your lawyer has looked through specifically the dates, and your lawyer determines that you have not triggered the 3 or 10-year bar, then you should feel good about going. So you have not been able to renew your DACA since 2017. Right now, if you let your DACA lapse for 1 year or more, they deem it to be a new application or initial application, even though it's not, and you cannot file it for renewal. I know, it's really a drag. Okay, if you are currently out of status, is it true that the only way to adjust status via employment is under 245I? So in employment cases, for the most part, you must maintain legal status. But that's not true if you're eligible to adjust status under 245I. So let's say you've been working for a company, an employer, and for some reason you let your status lapse. If you are 245I eligible based on a petition that was filed for you or your relative in which you're a derivative beneficiary, if you can adjust status under 245I, then you can pay the penalty and get your residency based on employment, because you are eligible to adjust status in the United States under the law 245I. So it happens to be true for a lot of people. Hopefully that answers your question. Yes, I take cases from all across the United States. I'm licensed in the state of California. I do $100 consultations. We can do it Zoom, WhatsApp, or phone. And I represent clients from all around the United States. Thank you so much for liking this. Okay, I think I have time for, one more question. Yes, it's okay to do advanced parole with a removal order. So you can call my office at 408-418-6621. My number again is 408-418-6621. And that's also in my bios and stuff. And you can call my office to schedule, or if you go onto my TikTok, you can do a square consultation. But you're so welcome. Yeah, I would love to have more followers. And I love that the immigration officer was on my live. Thank you so much. I'm sure you blocked me, so you won't have to hear me rant and rave, but maybe I'm educating a lot of people that are filing your way. And I'm going to say, what is your number again? My number is 408-418-6621. 408-418-6621. Thank you so much for being on this live. I truly appreciate it. I was a little tongue-tied because I started this morning at 9 o'clock and I had about 10 consultations. I'm all talked out. What I'm going to do now, once I get off this live, is go home, say hi, have a big glass of wine, and just turn the brain off. Because this stuff, I've been a lawyer for 30 years, and immigration law is very, very complex. I've done securities fraud. I've done police misconduct work. I've done a lot of different types of law. And for the last 12 years, I've devoted my life to immigrants and immigration law. And I will tell you right now, it is by far the hardest law I've ever tried to do. And it's not just forms, not by a long shot. So thank you so much. I can't believe it. It's been an hour. Thank you for Dreamers Together for letting me be on your live, and your group's doing great things. Hope to see you guys really, really soon. Thank you very much.